I'm Spencer Mazyck, and this is part 4 of our viewer's guide to the healthcare arguments, where we provide you with an explanation of the Obamacare issues pending before the Supreme Court. Joining us to discuss the issue involving Medicaid expansion is Roger Pilon. He is founder and director of the Center for Constitutional Studies at the Cato Institute. Welcome, Roger. Thank you for joining us today.
You're quite welcome, Spencer.
So let's just begin with, how is Medicaid expanded under Obamacare?
Well, Congress enacted Medicare and Medicaid in 1965, Medicare for the elderly, Medicaid for the indigent. It was designed as a federal-state partnership with the costs split roughly evenly between federal and state governments, although that varies from state to state. And it's a voluntary program, at least nominally, for the states, although by 1982 every state had enacted a Medicaid program on its own. Over the years, not surprisingly, the costs have grown and grown until today in many states it's the largest part of their budget. And that is in fact leading many states to object to what is being done under the Obamacare or Affordable Care Act.
Are the challengers to Medicaid expansion arguing that it is unduly burdensome to the states, or are they arguing that Congress just doesn't have the authority under the Constitution to expand Medicaid?
Both. Let's start with the latter, the burdensomeness. Right now, if the states decline to expand their coverage and the number of people who are eligible for this expanded Medicaid program, they will have to forfeit all that they currently get for Medicaid. And that, on average, it amounts to about 40% of their entire budget. In the state of Arizona, for example, they will lose 60% of their Medicaid funds from the federal government. Now, the interesting thing is that they will therefore have to make that up themselves. Meanwhile, their own state taxpayers will continue to have to pay in to the Medicaid program to fund the programs for other states. So when states say that this is no longer a voluntary program, that in effect it is coercive, they're absolutely right.
So are they saying, though, that Congress then doesn't have the authority under the Constitution to force them to take Medicaid or expand Medicaid?
Yes, that is the second leg of the argument, and that's this, that Congress could not directly compel them to set up a Medicaid program, because the provision for the health care of citizens of a state is part of the state police power, which belongs to the states. The federal government has no general police power, so the federal government could not order the states to do this. Now, what they are saying then is this: if they can't do it directly, they can't do it indirectly either. They can't make it as a condition of receiving these funds and, in effect, giving up the funds they already get, that they expand their program, because that is tantamount to coercion straightforwardly.
Hasn't the Supreme Court, though, reviewed this coercion theory, I should say, at least twice now? And what was the outcome in each of those instances?
Well, the main case is South Dakota v. Dole, that the states are that the federal government is relying upon. And the problem with that is this: South Dakota v. Dole had the federal government ordering the states to increase their drinking age from 18 to 21 on condition that they wouldn't receive their federal highway funds unless they did. The last holdout was South Dakota, but in that case it amounted to only 5% of the budget. Here we're talking about an average of 40% of the budgets of these states. And so the argument is that 5% was not coercive. This indeed was said by the court, that look, if it were more, then it would be a different case. Well, now we're at 40% on average. That's a lot more.
Do you think that the court is going to actually find the coercion theory viable this time, even though there's no dissension among the lower courts on this particular issue?
Let's put it this way. If I were betting, I would bet that they will find it unconstitutional. I wouldn't bet the ranch on it. I think it's going to be a close call. I think it will be narrowly decided. But I do think that on this, as well as on the individual mandate, we do have powerful arguments for saying this far and no further.
All right. Well, thank you very much for sharing your insight with us today on this particular issue. We really appreciate it.
You're welcome.
That was Roger Pilon of the Cato Institute. Stay tuned for the 5th and final installment of our series. But in the meantime, for more information on this or other topics, subscribe to BloombergLaw.com. Thank you for joining us. Bye, everybody.